本會發言，梁繼昌議員。
Mr. Acting President, in my capacity as Chairman of the Bills Committee on Inland Revenue Amendment No. 3 Bill 2015, I wish to make a report on the work of the Bills Committee. I shall focus on the major issues considered by the Bills Committee. The Board of Review Inland Revenue Ordinance is an independent statutory body established under Section 65 of the Inland Revenue Ordinance to hear and determine tax appeals lodged by taxpayers. The main objects of the bill are, first, to allow an appeal against the board's decision to go directly to the Court of First Instance on a question of law by abolishing the procedure of requesting the board to state a case on the question for the opinion of the court. That is, to do away with the present case-stated procedure. Secondly, to empower the person presiding at a hearing of an appeal before the board to give directions on the provision of documents and information. Thirdly, to provide privileges and immunities to the chairman, deputy chairman, and members of the board, the parties to a hearing, and other persons appearing before the board. And finally, to raise the ceiling of costs to be paid by the appellant as may be ordered by the board from $5,000 to $25,000. The purpose of introducing these changes is to improve the tax appeal mechanism in Hong Kong, as well as the efficiency and effectiveness of the board. The Bills Committee generally supports the proposals in the bill. In the course of deliberation, members have examined, among other issues, the proposed requirement for an appellant to apply to the court for leave to appeal against the board's decision on a question of law. The proposal threshold for the grant of leave to make such an appeal, and the reasons for not allowing the court to receive new evidence on hearing such an appeal. I will elaborate on the Bills Committee's deliberations on these issues. The bill proposed that, to appeal to the court against the board's decision on a question of law, the taxpayer concerned or the Commissioner of Inland Revenue is required to apply to the court for leave. The Bills Committee notes that, while there is support for such a requirement, there are views among the taxation professionals, including the Joint Liaison Committee on Taxation and the Hong Kong Institute of Certified Public Accountants, that the leave requirement is not necessary. The Joint Liaison Committee on Taxation argues that, while the decision of the board is final, leave is typically not required for final decisions in other civil litigation appeals, and the introduction of the leave requirement would defeat the purpose of abolishing the case-stated procedure, which aims to streamline the appeal procedure. Some members of the Bills Committee have expressed concern on whether the leave requirement, together with the requirement for the losing party in a tax appeal to pay the cost of court hearings, would deter a party aggrieved by the board's decision from appealing to the court. The administration, in response to these concerns, has explained to the Bills Committee that with the leave requirement in place, the issue of whether an appeal against the board's decision involves the question of law will first be dealt with by the court. Moreover, for the appeals to the court against the decision of the Labour Tribunal, the Small Claims Tribunal, and the Minor Employment Claims Adjudication Board on questions of law, leave to appeal is also required. On the threshold for the grant of leave, the bill proposes that the court must not grant leave to appeal against the board's decision unless the court is satisfied that a question of law is involved in the proposed appeal, and the proposed appeal has a reasonable prospect of success, or there is some other reason in the interest of justice why the proposed appeal should not be heard. Some members of the Bills Committee have queried whether it is necessary to codify the leave threshold in the law, given that the court would exercise its judgment on whether there is a proper question of law in a leave application. The Bills Committee notes the views of parties concerned that the proposed threshold of reasonable prospect of success is higher than that for the existing case-dated procedure, and setting the bar too high would add costs and delay in cases where the taxpayer has an arguable basis on which to proceed. The administration has explained that the leave threshold, as included in the bill, was proposed by the judiciary. The proposed threshold aims to enable limited judicial resources to be put to their best use by filtering out unmeritorious applications for leave during the leave process. A similar threshold has been introduced for leave to appeal to the Court of Appeal against a decision of the Lands Tribunal on the grounds that such decisions is erroneous in point of law, and for leave to appeal to the Court of Appeal from any decision of the district judge in any civil cause or matter. In the course of deliberation on these issues, the Bills Committee has inquired about the relevant arrangements in other common law jurisdictions. The administration has advised members that in places like England and Wales, the state of Victoria of Australia, permission from the relevant tribunal or the court is required for making an appeal against the decision of the tax review authority on a question of law. As regards the leave threshold in England and Wales, it is provided in the law that leave for such an appeal shall not be granted unless the upper tribunal or the Court of Appeal considers that the proposed appeal would raise some important point of principle or practice, or there is some other compelling reason for the Court of Appeal to hear the appeal. Having considered the reasons given by the administration, the Bills Committee has no objection to the leave requirement and leave threshold as proposed in the bill. Mr. President, it is suggested in the bill that, in relation to an appeal against the board's decision on a question of law, the court, when hearing the appeal, must not receive any further evidence on the case. The Bills Committee has studied whether this requirement is reasonable. Members have queried whether the requirement might be unjust to the appellant and contrary to the principle laid down in case law, that is, the court should have the decision to admit fresh evidence. The administration has explained that in an appeal against the decision of the board, the party to the appeal can only challenge the board's decision on a question of law, but not on grounds of fact. The proposed arrangement will preserve the function and the role of the board in receiving and considering evidence, and also prevent the proceeding of hearings from being affected by the submission of new evidence by either party during court hearings. There are similar provisions in the Labour Tribunal Ordinance, the Small Claims Tribunal Ordinance, and the Minor Employment Claims Adjudication Board Ordinance. As to members' concern about possible needs for new evidence to be heard for an appeal, the administration has advised that there are provisions in the bill which allow the court to remit a case back to the board with any direction that the court thinks fit. In other words, during the course of determining the question of law involved in an appeal, the court may return the case to the board if the court considers it necessary to obtain further evidence or facts. President, the Bills Committee supports the second reading of the bill. Neither the administration nor the Bills Committee will move any committee stage amendment. The following part of speech carries my personal comments on the bill. Mr. President, I had the privilege of being a member of the Board of Review for over 7 years between 1999 and 2006. The Board of Review is an independent statutory body constituted since 1947 under Section 65 of the Inland Revenue Ordinance to hear and determine tax appeals. The law provides that the board shall consist of a chairman and 10 deputy chairmen, who shall be persons with legal training and experience, and not more than 150 other members, all of whom shall be appointed by the chief executive. At present, the board is composed of 1 chairman, 8 deputy chairmen, and 63 members. The board has been functioning as an efficient, inexpensive, and transparent tax tribunal. In recent years, the number of cases arising from appeal from a determination from the Commissioner of Inland Revenue on cases relating to profits tax, salaries tax, and property tax is quite stable, reflecting the quality of decision of the board. In a nutshell, taxpayers have been careful not to make an appeal to the board on trivial and matters without chance of success. Between 2012 and 2013, the board heard 67 cases, while there were 46 new cases going up to the board. In 2013 to 2014, the board heard 78 appeal cases, while there were 70 new cases during the year. And as at 31st March 2014, the number of cases waiting to go to the High Court, including the Court of First Instance, the Court of Appeal, and the Court of Final Appeal, was only 8. Mr. President, the changes provided by the Amendment Bill are mostly uncontroversial and will improve the operation and give sufficient but not excessive power to the board, including, first of all, empowering the board to give directions on the provisions of documents and information for the hearing. Second, providing immunities to the chairman, deputy chairman, and other members of the board, and the parties to a hearing, as well as other persons appearing before the board. And third, raising the ceiling of costs to be paid by an appellant from $5,000 to $25,000. The amendment, which received more detailed discussion during the bill's committee stage, was the abolition of the case-stated procedure, which currently allows an appeal against the decision of the board on a question of law to go direct to the Court of First Instance, or, as the case may be, to the Court of Appeal. In the amendment, leave to appeal will only be granted if the Court of First Instance is satisfied that, first, the proposed appeal has a reasonable prospect of success, and second, there is some other reason in the interest of justice why the proposed appeal should be heard. Sorry, it should be or rather than and, Mr. President. Many legal and tax practitioners think that these conditions may defeat the purpose of abolishing the case-stated procedure and may stifle some genuine appeal cases. In Australia, a taxpayer has an automatic right of appeal from the Administrative Appeals Tribunal to the court, and no leave is required from either the Administrative Appeals Tribunal or the court. In the United Kingdom, leave to appeal is required for an appeal from the first-tier tribunal to the upper tribunal, although the law provides that any party has a right of appeal. The first-tier tribunal, in the case of Invita Food Limited 2014 case, invoked Rule 52.36 of Civil Procedure Rules of Guidance, which provides that permission to appeal may be given only where the court considers that the appeal would have a real prospect of success. I consider that the imposition of the appeal criteria unnecessary, since the fact matrix is that the number of cases going from the board to the higher courts is never high, and there does not seem to be an abuse of the system. The UK case demonstrates that perhaps it is possible that a court in Hong Kong would interpret the term reasonable prospect of success in this limited manner to mean arguable, which is a criterion accepted in Hong Kong under the current legislation before this amendment bill. However, uncertainty remains. On balance, though, I will not table any amendment and would leave to the good sense of the Court to interpret the relevant provision. Mr. President, I would like to draw to your attention that the Board is a model example of a good technical tribunal, and professional accountants are used to its way of operations. Indeed, when I raised this model to many of board members of the Financial Reporting Council, many of them expressed a personal view that the board's model should be the ideal model for the future disciplinary board of the Financial Reporting Council. It is independent, functioning, and cost-effective. And yet, I very much regret to say that many, I say many, in the FSTB are taking a red tape approach to dealing with the disciplinary function of the FRC, citing the Securities and Future Commission as a model. And yet, professional accountants, Mr. President, are not stockbrokers or dealers. And many of our decisions are technical, and the doing up and the expression of an opinion, an audit opinion, on a set of financial statements is an art and not a science. While other professionals, including the solicitors and the medical practitioners, have their own independent disciplinary tribunal, the least professional accountants would want is to have a super regulator which is vested with investigation, prosecution, judicial and enforcement functions. In short, all disciplinary cases which cannot be settled between the alleged offender and the FRC should go to an independent disciplinary board modeled after the Board of Review. And I would like to urge the Secretary for Financial Services and the Treasury to reconsider this aspect of the regulatory reform for the professional accountants engaging in listed company audit. Please do not easily give up a model which has been functioning for over many years and take a broad brush approach to tackle a sensitive issue. Mr. President, in summary, I would like to urge my colleagues across the board to support the resumption of the second reading and the passage of the passage of the bill. Thank you, Mr. President.
有冇其他議員要發言？梁國雄議員。